Okay.
28.
Samuel.
Yeah, put 12. So one session, 28.
Is that we all ready? Okay. Good afternoon, distinguished friends from the media. As always, we are grateful to you for the opportunity to address the nation and by extension the world on the course proceedings on the 2020 election petition, a matter which is of considerable public interest. Several things happened in court today. The first was that counsel for the petitioner moved an application for leave or an application for review of the court's decision on 16th February, which is the court's decision on our application for leave to reopen our case so that we could subpoena the chairperson of the Electoral Commission to testify. Now, for those who are not lawyers, an application for review is a right given to any party dissatisfied with a decision of the Supreme Court to apply to the court and invite the court to respectfully review or change its own decision. And Article 1331 of the 1992 Constitution and the decisions of the Supreme Court has made it clear that you can apply for review of the court's decision, and in fact the court will review that decision where there are exceptional circumstances such as fundamental errors of law committed by the court which have occasioned a miscarriage of justice. And so today's application for leave that counsel for the petitioner moved was to achieve just that, to demonstrate to the court that in its decision of 16th February, certain fundamental errors of law were made, and to invite the court to remedy or rectify those errors by reviewing its decision in the interest of justice. Now, the grounds that counsel for the petitioner relied on in moving this application was that, one, you would recall that when counsel was moving the application for leave for the court to allow us to reopen our case, he was asked in what capacity he was seeking to call the chairperson of the first respondent, and he answered by saying that the petitioner was going to call the chairperson of the first respondent, the EC, as an adverse witness. And so you would recall that in the court's decision, the court stated that in their opinion, it was wrong for counsel to have said that he will be calling the chairperson of the first respondent as an adverse witness because per the Black Law Dictionary, a witness can only be described as an adverse witness after the witness has entered the box. And if it is detected during the evidence in chief of that witness that he or she is giving evidence adverse or contrary to the case of the party examining him or her, then that witness becomes an adverse witness, and counsel can then apply to the court to treat the testimony of that witness as that of an adverse witness. That was the decision of the court. Now, ground one of today's application argued that that decision of the court was a clear fundamental error because it did not take into cognizance Section 72 of the Evidence Act. Section 72 of the Evidence Act is simple. It says that subject to the discretion of the courts in a civil action, a party or a person whose relationship to that party makes his interest substantially the same as a party may be called by any adverse party and examined as if on cross-examination. And so if you are a party or you are a witness or any person and your interest in the case is substantially the same as a party in that case, then an adverse party can call you to give evidence. And so in our respectful submission that we made to the court through counsel for the petitioner, one does not have to enter the box before that person can be described as an adverse witness. And that Section 72 of the Evidence Act allows a party to call a person whose interest in the case is substantially the same as another party in that case as an adverse witness. And so for us, the court's decision for this reason was per incurium. Per incurium basically meaning that it was without recourse or it did not apply this section. And for us, this is a very serious fundamental error because as the court itself has held in several decisions, the court is the servant of the legislature and must apply the rules or the laws that the legislature, passes. Then secondly, counsel for the petitioner argued that the court committed another fundamental error of law when it stated in its ruling of 16th February that Section 26 of the Evidence Act is inapplicable. It wouldn't apply Section 26 because of Order 38, Rule 3E5. And just to break this down so that those watching can understand, counsel for the petitioner has argued, and we have explained or elaborated that point here on several occasions, that for us, Section 26 establishes the principle of estoppel. And that section basically says that if through your acts, statements, or omissions, you intentionally and deliberately makes another person to believe a thing to be true, then the truthfulness of that thing must be conclusively presumed against you. That person having relied on that representation from you, which basically means that if per your actions you make me believe that you will do something and I rely on that, the court should not allow you to resile from that position. And we have explained that. We are saying that Jean Mensah, through her depositions in at least 2 affidavits before the court, made it clear that she will be available for cross-examination to answer certain questions. And so she's bound by Section 26 under the rule of estoppel to change her position. And in that ruling, the court said, because of Order 38, Rule 3E5, we will not apply this. And we, today, counsel for the petitioner respectfully submitted that that was a fundamental error of law. Because number one, Order 38, Rule 3E5 has got nothing to do with the principle of estoppel and a witness or a person being, being held by the court as bound by a previous representation. That order has to do with a party having the right not to call a witness who has already put in a witness statement. The purpose for us relying on Section 26 had nothing to do with a party. It had to do with Jean Mensah as a person. And so for us, that was completely irrelevant. And counsel for the petitioner further argued that even if there was any relationship between Order 38, Rule 3E5 and Section 26, Order 38, Rule 3E5 could not be interpreted or construed as having precedence over Section 26, because in the hierarchy of laws, a constitutional instrument is subservient to an act of parliament, and Section 26 is provided for in the Evidence Act, which is an act of parliament and which is superior to Order 38, Rule 3E5, which is a subsidiary, provision in made by the Rules of Court Committee. Again, counsel argued that the court did not take cognizance, or the court did not apply Order 38, Rule 10 of CI 47, which counsel indicated to the court that he was going to apply should leave be granted for the petitioner to reopen his case. He said, I will follow this rule, Order 38, Rule 10, which is basically the rule or the process for the issuance of a writ of subpoena. And that the court's decision did not make any reference not only to Section 72 of the Evidence Act, but did not also make any reference to Order 38, Rule 10, which we had indicated that we were going to rely on to subpoena Mrs. G. Mensah. Then he spoke about Article 19.3 and Article 296 of the 1992 Constitution. And Article 1913, has to do with an adjudicating body acting independently, impartially, and ensuring that a case brought before that body, is conducted in line, fairly, in line with a fair hearing. And in our opinion, counsel for the petitioner submitted that if you look at the way the court has failed or refused to apply certain statutes, and the court appears to be shielding, in fact that is in his statement of case, shielding the EC chairperson from accountability or testifying, it is not fair, and it violates the petitioner's right to a fair hearing as stipulated under Article 19, Clause 13 of the 1992 Constitution and Article 296. And the question we always ask, which we would like to reiterate today, is that why must we go through all these tedious processes just to get a public officer who we pay as citizens of this country, a public officer who has discharged a certain constitutional duty by conducting elections and declaring the outcome of same? We are talking about G. Mensah, the returning officer for the 2020 presidential election. Why must we go through all these hassles, all these troubles to get this woman to just give account of her stewardship, how she did her job, and how certain things happened, so that the courts can know the truth in these matters and do justice? If she has nothing to hide, if she has done nothing wrong, why must we go through all these tedious processes? Now, there were questions about, but you close your case voluntarily. Yes, we close our case based on the representations of the EC chairperson that she was going to be available for cross-examination. And at the time we were closing our case, we could not have subpoenaed her to testify because she had filed a witness statement and several affidavits which had made it clear that she was going to testify for the first respondent. And so the law and the rules of this court would not have allowed us to even subpoena her at the time. So this issue of, you close your case voluntarily, you cannot, no. The last time, the president of the bench stated clearly that it is a settled principle of law that a party can apply for leave to reopen his or her case after he has closed his case. And that is what we have done, and we believe that we have demonstrated that the circumstances or the conditions which are important for for leave to be granted in such circumstances have been demonstrated. The court dismissed this application and said basically that we failed to show the reasons why we were seeking to subpoena Madam G. Mensah. Now, because of time, I will not go through our statement of case and all that, but you can check paragraph 28 and paragraph 42, and you can see for yourself that counsel for the petitioner and the petitioner explained clearly why we need G. Mensah to enter the box. We explained that she is a returning officer who made a declaration of 9th December. It is she who claims to have made errors. It is her outfit which purportedly sought to rectify that error through unlawful means. It is this same returning officer and her office who have sought to churn out conflicting and inconsistent figures. And that it was important, among other things that we say, it was important that she be made to enter the box, cross-examined, so that the truth in these claims could be unearthed for Ghanaians and the court to appreciate all these things. So we disagree with the court that we did not show why we are seeking to subpoena G. Mensah and the usefulness of her testimony to the determination of the issues before the court. We believe that the evidence before the court shows that we did that. Again, the court, in interpreting Section 26, commenting on that, said that, There are certain conditions when it comes to promissory estoppel. Now, it's instructive to note that counsel for the second respondent, Lawyer Kutampa, had suggested that G. Mensah didn't even make any representation to us that we could have relied on. And that what G. Mensah did was basically to state the position of the law that she will be available for cross-examination. That was not a representation, was not an undertaking. Those were his words. Now, the court in this ruling says that it is a representation, but same cannot be said to be unambiguous. In other words, it is ambiguous. We have read those depositions over and over again. Those depositions are undertakings. Per section 26, G. Mensah is bound by same, and there is no ambiguity in those depositions. She says clearly that the petitioner will not suffer any prejudice or injury because the petitioner can solicit the answers he is seeking through interrogatories during cross-examination. And we believe she meant what she said. Before I conclude, again, the court spoke about section 72 of the Evidence Act that counsel argued on in this case. And the court said that there is no inconsistency between the Black Law Dictionary decoded and section 72. Yet the court still stands by its definition of who an adverse witness is, that a person must enter the witness box before he or she can be described as an adverse witness. Clearly, you can all download the Evidence Act 1975 and read section 72 for yourself. It says that, among other things, a person whose relationship to a party makes his interest substantially the same as a party may be called. So you can be called to enter the box as an adverse witness. You need not be in the box before, on the basis of your adverse testimony, you are described as an adverse witness. And so there too we disagree with the court. But ladies and gentlemen, a lot happened today. We do want to bore you with all the details. The bottom line is that the petitioner is worried that the courts, in deciding these applications, are not applying statutes that have been passed by our parliament and statutes that the court has been applying in other cases. And we think that the petitioner is being denied a fair hearing, and it is important that these issues be pursued to their logical conclusion. Now, why are we doing all these things? We are doing these things because of the constitution that all of us as Ghanaians have agreed to be bound by. Article 63.3 of that constitution says that no person should be made a president until and unless he attains more than 50% of the total valid votes in any presidential election. And it is clear from G. Mensah's own declarations and the figures contained therein that candidate Akufo-Addo did not get more than 50%. We've done the mathematics here over and over again, and you can do the mathematics yourself. He did not cross. And so the petitioner, John Dramani Mahama, His Excellency, is doing this for and on behalf of all of us, and he's doing this in defense of the Constitution. And so we must all be interested in this case. Let me appreciate those who have been encouraging us and cheering us on. We really appreciate your encouragement. And we are assuring you that we are not giving up, we are not giving in. We are fighting this matter in the interest of justice and for God and country to its logical conclusion, so that tomorrow an EC chairperson or an EC will not arrogate to themselves the power to choose leaders who have not met the constitutional threshold that we have all agreed to work with. We don't want that bad precedent to be set. The will of the people must always hold sway over the will of a select few. And for those who are crestfallen, those who are discouraged, and sometimes call us worried, disturbed, why don't you withdraw this matter? Why you shouldn't even go to court? We want to tell them that we understand and appreciate your frustrations. We understand and appreciate that. And we are telling you, don't give up. We are not doing this for nothing. We know what we are doing. And we are doing this because of the love we have for Ghana, particularly that of the petitioner. And so let us all be patient with the legal team as we go through the process. We are not abusing the court processes like some are suggesting, and we have not defied the orders of the court. Everybody knows that any party dissatisfied with the decision of the court is entitled to a review. And so we are just using processes provided for under the laws of this country that we have all agreed to be bound by. And let me just say finally, like I said last week, that no matter how this case will go, no matter how the decision will go, because we are all discerning, because we all love the truth, because we are all following this case keenly, the truth will become clear to all of us and we will all see the truth. And don't always think that when people come to court and the applications are dismissed, it means they are wrong. No. What it means is that the court is right for the time being and it is what the court has said that will prevail. Like now we disagree with the court, but whether we like it or not, what the court has said is the law and that is what will prevail. But posterity will be the judge of us all. Just like it happened in the case of Ray Akutu, when the Supreme Court then unanimously dismissed the case brought before it by Joseph Dankwa, J.B. Dankwa, with regards to the unconstitutionality of the Preventive Detention Act. Today, even though the court held in that case unanimously that the presidential oath was akin to the coronation oath of the Queen of England and didn't constitute a Bill of Rights and all that, today, what is celebrated is not the court decision. In fact, that is the most unpopular decision in the history of this country, even though it was a unanimous decision. What is celebrated are the submissions of J.B. Dankwa. And we believe that posterity will judge us very well. Will judge us very well. Now, we are hoping, based on the indications that the court has given, that they may find it necessary for counsel to be given the opportunity to make some submissions, oral submissions, on the written submissions they have been asked so far. There's not been any clear indication to that effect that will be done, but the court says that if it finds it necessary, the court will do so. We think that looking at the considerable public interest in this matter, it will be important for that to be done. But if the court, in this wisdom, decides that they are not going to allow counsel to make any oral submissions, we will respect that, and we will be engaging you in the media, and we'll be sharing with you the content of counsel for the petitioner's written submissions. And so that is where we'll end it. If you have any questions, you can ask. Of course, in 2013 it was done. So we are hoping that that precedent, which is a very good precedent, will be repeated in this case.
Thank you. Two quick questions. The ordinary bench and the application to reopen, a 7-member panel, dismissed the application. We have an enhanced panel, 9-member panel, equally dismissed the application. Obviously, from what you have said, you are dissatisfied with the decision, but you have to file your address anyways, and you would have to do that, close the case, file your closing address without the benefit of the testimony and cross-examination of the EC chairperson. Question number one, are you disappointed? Question number two, is the NDC going to be seeking another opportunity to hold her accountable, as has been the talk all throughout?
Okay. So the first one, are we disappointed? Yes, we are disappointed. We are disappointed that, in our opinion, the petitioner is not being given a fair hearing. We are dissatisfied that, in our opinion, it appears that the EC chairperson is being shielded. We are dissatisfied that, in our opinion, and as articulated by counsel for the petitioner, known principles of law and statutes that our parliament has passed, that the court has previously applied, are not being applied to this case. So, in our opinion, we are not being treated fairly and we are disappointed. But the decision of the court is what prevails. And to answer your second question, are we going to explore other opportunities or avenues to hold her accountable? Emphatically, yes. We will explore. We mean it when we say we will explore all options and fight this matter to its logical conclusion. Any other question? Okay. So, Baba will do this.
Yo, anyone, I say, ne court by no, in Sembe, you know, NDC or court her. Yedi kan em say a system fi atwemu court si ginae bi ginae o si ni so on my ho kwan me mie ya asem no mu sene ebe ye betimi afra ma meje mensa na waba abeka nanu mu nsa no wa kire ni esi wo abatro no enne ye samba say court nsan hwe ni ginae ne biom esan say yen ya dwemu de enim se ma me gye mensa wa ma no kura wa asem ye hunu ono ana o declare election no ono ana o ma em figures different ono ana o kire se na Akufo Addo wini a yen susuye mu ne yankundabu mu no na Akufo Addo wenya 50% plus one wenya enjiti e ba be kansem na so ono amma amaka bidia na jeza asem na kan no na enwie feyo ye kan enu mu nsem biara nanso court no ene ye anya adwen court no enyina ye ne se ono de ofo se ma meji mensa ba enyeyi saa semi ene asem esi o court na ye ne ye gusu ejina bebi ejina se court na kasa de na ne court mu so beka ene ye mra be no so nkyerɛ se be za woni court nya adwen a wontimi nka wasem eye mi nua kasa no oma decision bi a emre bi court na si ejina ya court nipa na wo hoyi na aka se ni oma kan na enukure na nsi ebe kire no na asem no asesa enti yen ye gidie mu de enim se asem na ye kono ne court kan ye no wa kan de na yen so ye no mu nya adwen ye beti ye hye Ghana fo ina bo se ne ye no enya ti ye no kwa ye ni si enim ne ye Don Dramani Mahama wotunu wati ho so obabo mu obiara court nsema wakan obi atiase wotunu ho gina ho se no kura wasasem no mu na wo se pie enti se obi gina ho na okase bi o adentina mo koso ye adentina mo nya ne ye pese obi atiase ne se Don Dramani Mahama ogusu gina bebi ogina ne ebe ye biara kwan bi foforo bia wo ho na o se ye faso mama me no obeka na num nsem ma no kura no de di magana fotia inshallah ya duwan baba. Salamu alaikum jama'a. Yau kuma mun zo court. Inda muka zo court abinda muka gani yau shine matan da ta saya aka yi wanga takara. Matan muna so ta zo ta shiga cikin takaran. Ta shiga cikin adaka ta yi magana mun yi court wai bai ra'ayi da mu ba. Amma abinda muke so jama'a su gane ba wai ka zo court naka yadda maganan ka ya kare ba. Akwai hanyoyi da yawan da za mu bi ba kuma abin da za mu bari ba za mu ci gaba inda za mu bi matan ta shigo ta bari jama'a su gan gaskiya a me ya faru domin ita ta zo ta yi declaration nan ita ta sai aka yi takaran abin da aka yi duka ita ta yi to don me za zo yi magana a ce babar ta shiga a daka don me za zo a kawo magana ta ce ba yadda yau mun zo court wai bai yadda da mu ba amma abin da muke so mu gane in kotu bai yadda da mu wannan bai gwada kuma magana ta kare ba za mu ci gaba inda za mu bi magana ta kwanta matan ta zo ta faɗi gaskiya ko yau ne ko gobe ne ko zuwa gaba ne za mu bi mu bar ta zo ta yi gaskiya. Assalamu alaikum.
Please, Dr. Ayine will address you briefly. So.
Madam, we'll stand by.
Let's all stand by him.
Who's coming? That's okay, I'll stand. Yeah. They're party for Dominic. That's okay,
Okay. Thank you.
I'll stand beside you. I'll stand beside you.
Okay, all right. Yeah.
Let's stand.
Okay. All right. Good evening, ladies and gentlemen of the press. I am here this evening in respect of the remarks that are made to you on the 16th of February after court proceedings. Those remarks were widely publicized by the media, and both mainstream and social media carried them and they went viral. I have looked at what I said that day, and I have come to the conclusion that I went overboard, I crossed the line with respect to the remarks that are made in terms of attributing impropriety to the Supreme Court of the Republic of Ghana. And I just wanted to let you know that this morning I delivered a letter to His Lordship, the Chief Justice, offering an unqualified apology to the court. Now that letter has been filed and the Chief Justice of the Republic has referred to it, I want to take the opportunity to read the content of that letter to you, and thereafter I will apologize and retract my words. Now, the letter reads, My Lord Chief Justice, summons to show cause unqualified apology to the Supreme Court. On the 16th day of February 2021, I addressed a press call at the premises of the Supreme Court in respect of a ruling that the court had rendered on that day. I did so in my capacity as a member of the legal team of the petitioner, with instructions to brief the press on matters of concern to the petitioner after court proceedings. In carrying out my instructions on previous occasions, I had always made certain that I explained the day's proceedings to the understanding of the press corps and of fellow citizens with civility, and without seeking to attribute acts of impropriety to the Supreme Court or the respondents. On the said day, I thought I had maintained that approach to the press briefing, but on hindsight, I actually crossed the line in suggesting that the court had a predetermined agenda, among others, to rule against the petitioner. My attention was drawn to this fact immediately after the press briefing by Frank Davis, Esquire, to whom I am grateful. It was not my intention to scandalize the court or to bring it into disrepute. In the circumstances, I wish to apologize unreservedly to the court. Yours sincerely, Dr. Dominic Akuruting Ayine, signed. And for those of you, I'm sure Mr. Frank Davis is not a stranger to the press. He's standing here to my right. I remember on the 16th of February when I finished addressing the press, he walked up to me and reminded me that the phrase that I had used, that there was a predetermined agenda, had crossed the line. And that is when I started thinking about whether or not I had crossed the line. And I agree absolutely with Mr. Frank Davis and those of you who think that I crossed the line on that day. I wish to unreservedly apologize to the court, that is the Supreme Court of the Republic of Ghana, as well as the justices in particular who sat on that day. There was no intention on my part to impugn their integrity. I was just expressing a sentiment with respect to the ruling of that day. And I want to render an unqualified apology and to retract the words that I used on that day in their entirety.
Unreservedly.
Unreservedly, I will not in any way want to disparage the Supreme Court of the Republic of Ghana. You can see I'm lost for words because I don't want to be, when you want to take a pegative, I was told that I should purge myself of the contempt. So you take the pegative so that you don't complicate the constipation. So I'm being very careful that the pegative I'm taking this afternoon will not complicate the constipation. And so I wish to thank the press for the opportunity to address you, because His Lordship, the Chief Justice, in making the order, said I should use the same medium that I used in conveying the words that are the subject matter of the contempt proceedings. And so thank you very much, ladies and gentlemen of the press. I am hoping that my apology and retraction will be accepted by their lordships, and the matter will come to an end. Now, in respect of this matter, I plead with the press that I won't take any questions and provide any explanations. God bless you and God bless our homeland, Ghana. Thank you very much. Thank you.
Colleagues, good afternoon. We'll make it pretty snappy because we can tell that you have a big story today, bigger than all that has happened in court. So we'll make it pretty snappy. I think you have followed for the several hours of today the legal arguments that were made by counsel for the petitioner and then responded to by counsel for first respondent, counsel for second respondent. I think at the end of the matter, I want to draw your attention to the words of the Supreme Court speaking through His Lordship the Chief Justice in ruling. And I want to focus on that because lawyers express their opinions on the law, what they think the law means, what they think a proper construction of the law ought to mean. And I think today you are noticing that our friends on the other side now keep using the phrase that in our opinion, in our opinion, in our opinion. Initially, the argument was as though it was fact. But you notice that the point is being made that people express opinions, the court determines in the end. The court has said that the legal arguments, the provisions of some of the acts and the CI and some of the authorities that the petitioner's legal team tried to invoke, together with the principles of equity, and if you just listen to the court, it says that the positions that they were expressing are not supported by the law or the principles of equity. So even a reiteration of it before the press and a re-explanation does not change the fact that the law does not support the position that they've been expressing. And so we will not go into a reiteration of all the legal arguments that we made. I think this is about the third time that the court has dealt with this type of issue and has come to a certain conclusion on it. The court also says that they did not satisfy even the minimum threshold required to sustain an application of this nature. You know, sometimes when we make this point, it appears as though we ourselves are saying it. We are not the ones saying it. The court, I think this is the third time that the court has made the argument that the law does not support their position. They have not met the legal threshold. So we are not the ones saying that what they are saying does not align with the law. For someone to say we are disrespecting our seniors, etc. The court, the Supreme Court of the Republic of Ghana, is the one that is making the point that they have not satisfied even the minimum threshold. So we won't bore you with too much detail. The court has decided that on the 4th of March, judgment should be delivered in this matter. This is after the petitioner who came to court, among other things, arguing that nobody won this election, has called 3 witnesses, and has now, I think in the last 2 or 3 applications, been praying the court to literally force the EC chair into the box so that he can reopen his case and advance something else which he hasn't told the court, something else that can help make a better case for him. The court has decided that despite its earlier warning that if its processes are not complied with, it can strike out the matter, it will still accommodate them so that they can file their written addresses. I think this is clear evidence that nobody's being denied a fair trial here. The court has bent itself backwards and is accommodating the interest of all parties. So we look forward to the 4th of March for judgment. If it is the view of the court that they want to invite our lawyers, viva voce, to address some issues, they are more than prepared so to do. But Ghanaians have followed the journey that has gone on so far in the courts, where the petitioner was being looked to adduce the evidence. I heard our colleagues here saying that the mathematics is clear, but you have been here covering for all the days that we have been here. And I'm not sure that to you saw mathematics that yielded results other than 47% for the petitioner, Mr. John Dramani Mahama, and 51.2 for the second respondent, Nana Addo Dankwa Akufo-Addo. That was the mathematics that you saw Mr. Johnson Asiedun Ketia arrive at. That was the arithmetic that he arrived at, the answer that he arrived at when he did the various computations. Today you are hearing them telling you that the mathematics is clear, is nobody crossed the 49%. But in the wells of the Supreme Court, before the justices, and I'm not sure you have seen them prove that. But in any case, we'll come back on the 4th, and then we will stand by for judgment. So we'll keep it simple. We'll take your questions, and when I'm done, my colleague Nana B will do a quick Twi translation, and then Faisal will do a quick Hausa translation for us. We're going to take your questions.
Sami Jenfi stated that after this proceedings, if unfortunately the ruling goes against them, they're going to use any other institutional measures to still bring out the fact that they need from the EC chair. I want to ask, are you also ready to counter all the...
So for those who didn't hear the question, his question is the admission by the petitioners team now that they are willing to explore other avenues for the so-called accountability and truth that they talk about. First of all, let us reiterate that the truth is what has been laid before the court. The truth is what has been gazetted. That Nana Addo Dankwa Akufo-Addo, when you add the 38,000 plus polling stations, or you add the 275 constituencies, or you add the 16 regions, the truth is that Nana Addo Dankwa Akufo-Addo crossed with over 500,000 votes as a margin. It is the petitioner who seeks to challenge this truth, but has not brought his truth to court. Whatever counter evidence that he may provide to cause even the chair of the first respondent to get into the box, I'm not sure you have seen it here. But today they are admitting before you that they are willing to explore other avenues of accountability. Remember, about 2 weeks ago, we've been arguing before you that if you want accountability, generally, you can come to Parliament. The parliamentary committees of inquiry that can look into whatever matter you bring, and there's a 137 plus 1 Parliament. You can come to Parliament. You can come under the Right to Information Act, asking for some particular information. If it's judicial review that you want, that you think that the EC has not done something specific and the courts must bring its power to bear on it, the high courts are there for judicial review. So it is interesting that at the end of the case, when we are all wondering where the evidence that they were supposed to provide to back their case is, they are now opening up to you that they are willing to consider other platforms of accountability. We'll see which ones they choose, what case they make, and if there's any adverse arguments that need to be made there, we'll respond accordingly. Are there any other questions? Like I said, we know the big story that you have today, so we won't bother you with too much talk. Nanabi?
Yes. Abusiafo ene omana de share